Well, around him was a bit of controversy, interdicts, court challenges, people saying that, members of the family saying that they have their own person. And we understand that AmaZulu royal princess's court bid to stop the entering of the kraal by the King MisuZulu, kaZwelithini. To explain a little bit more about the legal implications, according to the law, we're now joined by MD of Zikalala Attorneys, Mpumelelo Zikalala. Thanks so much indeed for joining us, and welcome to the program.
Good evening, Peter, and also good evening to the SABC viewers.
All right, let's start right at the top, I think, with a broad view about how the law works when it interacts, and sometimes works separately to the traditional setups in our country.
The law takes a neutral view and simply says all that you're going to seek to do as the court is to check whether things are done in accordance with the customs, with the acceptable rules, with the acceptable practices. So what you go to the court to say, you simply say, they've been non-compliant with our acceptable rules and customs, can you please come to my aid? Now, there's an added factor, especially taking into account what happened earlier today, of saying that if you then come to court on an urgent basis, you then say to the court, I have a right in terms of the customs in which I were referring to earlier, and those particular rights are going to be irreparably harmed if you do not grant me the relief that I'm seeking today. So the court will have to sit and check whether there is agency, and then after that, look at the merits. Now, if, for example, as it happened earlier today, you knew well in advance that a certain ceremony was going to take place, and you didn't do anything. If there are other avenues or alternative dispute resolution mechanisms that are there that you can follow, but you've chosen not to use them, then the court is going to say, I'm striking your matter off the roll for the lack of agency. Come back at a later stage once you've got all your ducks in a row. But most importantly, when you are going to give your opponents ample time to respond to this particular allegation so that we're able to reach a fair decision and a just decision as the court.
Is there still a decision to be made by the courts? Is there still an assessment that needs to happen?
It will depend on the nature of the relief in which the applicant seeked. If the nature of the relief was simply to say, stop this particular ceremony from taking place, and it ends there. So there's no part B to the relief, maybe to say, remove or recall the recognition that has been done or conducted by the president, go and interrogate further whether the meeting of the Zulu royal family took place in a proper manner, then it would mean that the matter is going to die natural death today. Because if you go to court on another day, you can't implement anything that has happened before. So you can't backdate any of the orders and ask that things withdrawn if they've already taken place. Now, it is important to look at what exactly were they looking for, how was the order crafted. If it means that at the end of the day, you can't go back to it, it means you may have to file a fresh application if you so believe that you have merits and that the case that you are coming with will be winnable when you go to court.
All right. So, you know, as lay people, we watch this and perhaps we have other jurisdictions, other cultures that have guided us in the past. It seems as if a lot of what's happened in this instance could be open for interpretation, and that's why so many people are making these claims. How then can a court sort this out? It's not as if there's a constitution that's there that can be read and adjudicated.
You are correct, but then you have to separate between the two aspects. The first one is to say, what are the traditions and the customs saying, which is not codified, as you've correctly put it. And then secondly, you look at the part in which has been codified, which is the Concert and Traditional Leadership Act, and check instances of compliance. Let's start with the codified one. It's easier. It simply says, Mr. President, once the family has sat down as the royal family, they will submit a name to you. You must recognize that particular name. So to check whether there's been instances of non-compliance, you look at that process and you highlight those instances of inconsistencies. Now, when it comes to the traditional part, you simply have to go back and say, this is how things were made or were done previously. These are the main inconsistencies that have taken place, which is why I'm coming to the court to prove or to state that things have not been done in a correct manner. Now, to do that, the simple rule when you go to court is that whoever that alleges must prove. So you must be able to go to court and say, I'm going to court as an interested party. My source of the information in which I'm relying on is this person, Mr. So-and-so. They've also deposed to an affidavit. Their credibility as an expert when it comes to a manner in which a king ascends the throne is in this particular manner, and you can check that he's really a credible person to give advice and opinion based on their experience. And only then the court will be able to hear you and be able to adjudicate the matter. Let's remember, the court is simply there to say, I'm only going to interpret whatever that is there. I'm not writing the law. I'm not determining whether a certain process has been done correctly or incorrectly on something that I don't have already on paper that I can review. That's the only thing that I do at the end of the day as the court. I review what is there and check whether there have been instances of compliance. If there have been none, then I'm going to say, go back and restart the process again. If you can't prove that to me, then I have to dismiss your application.
The calling for an interdict, does that give us a clue that there is a partway acknowledgement that once today happened, it possibly could have been too late to change it after the fact?
You are correct. Maybe in a cultural sense of saying that they now understand the symbol of going into the kraal, what it means culturally. There's also an understanding that once you have done that, you have completed the traditional process of appointing a king or making sure that the journey to a king being fully appointed as a seal, this is what must happen at the end of the day in order for you to comply with the traditional aspect. So it seems as if there was a bit of acknowledgement or the significance of this particular ceremony was well understood by the applicants. They knew exactly what was going to happen, hence they didn't want it to occur. But the most important question would be, if you know that particular importance, why wait up until the last minute before you go to court? Why didn't you go to court at an instance in which the president would have issued the certificate? Why didn't you go to court 3 weeks ago, for example, and only go to court the day before? Because if you give your opponents ample time to respond, then it's easier for you to fight the question of agency rather than if you call them yesterday night and say, tomorrow morning, meet me at court. The court is going to be partly sympathetic to respond and say, I would like to adjudicate your matter. However, I can't do it if I haven't given all the relevant parties enough time or ample time to respond. So what you have done, you're putting me in a very tight corner, and I have to stick with the rules or the principles of agency. And in this case, your matter is not urgent. There's no irreparable harm, and the other alternative means that are there. But the mere fact that you've came here, it means at the back of your mind, you do realize the importance of this ceremony. And it may be that maybe there's a tacit acknowledgement that the process of appointing the next king or the next sealer has been done and completed by the event that took place today.
The courts, as you say, remain neutral. One of the contentious issues is that a will may have been forged. Does that change the game if that can be proved? Do we then now revert to criminal law and set aside that will, but that doesn't necessarily then say this person then must take over in his stead?
According to the customs and also to the Coronation and Traditional Leadership Act, a king is not appointed by the will. But the will is important in this case, or maybe it showed the intention of the wishes of the late queen. Now, if you go back and you listen to the way in which that particular clause was drafted in the will, it was merely a suggestion. It says, I, as the queen, I suggest that we appoint King MisuZulu as the next king of AmaZulu. But I'm giving you the discretionary powers as the Zulu royal family to decide who would be the most appropriate person. However, my wishes would have been that King MisuZulu would be the one that would be appointed as a seal. The significance of that is that if you look at it from the applicable legislative framework, the discretionary powers of the Zulu royal family members was not taken away by the will. So whether the will existed or did not exist, hence meaning whether it's valid or it's not valid, it has no bearing whatsoever, because the most important element to interrogate whether the particular aspect happened in line with the law would have been, was the king chosen by Zulu royal family members? If the answer is yes, part of the compliance has been done. Were they unanimous in the choosing of the seal of MisuZulu? If you also tick that box, that means you've complied with the traditional legislative framework, which the president would have used to recognize the king. Another aspect of which on the traditional side would be, according to the customs of the Zulu royal family, how do they sit and convene this particular meeting? How do they do an elimination process of all the names that are thrown in? Is there even a nomination process that takes place? And who presides over such a meeting so that at the end of the day it becomes an authentic one? So at the end of the day, the will does not come into the process of appointing the next seal. In this case, the uniqueness of the will is simply carried over the suggestion of the departed queen, and it had no bearing whatsoever as to the authenticness of who should be appointed as the next seal of AmaZulu.
Attorney at Law, Mpumelelo Zikalala, thank you so much. Your insights greatly appreciated, and we are fearful that you're going to send us a huge invoice now after that consultation. Thanks so much. Good talking to you. All right, that's Attorney at Law, Mpumelelo Zikalala, giving us a breakdown, and I hope that you were able to follow that, because it is quite complex, but the courts will sort it all out, and very soon the dust will settle.